acts criminal fraud under Florida statutes. What exactly is fraud? Most people mistakenly believe that the criminal act of fraud is perpetrated when an alleged suspect makes a statement that he or she knows to be untrue. All of us are familiar with the term fraud as a slang, whereby someone who is considered to be dishonest is referred to as just that, a fraud. The criminal offense of fraud, however, is punishable under Florida law by a restraint on liberty, jailing, imprisonment, probation. So what does that tell us? That tells us we're dealing with something much more precise. Florida criminal defense attorneys, along with prosecutors they are up against, must operate within the very strict confines of statutory law, case law, criminal procedure, the evidence code, and in many cases, even the local rules. The reason I'm not going to go on about this is because it can be catastrophic for both the state attorney, client, defense attorney, any party that may convince themselves that in the process of this litigation, this criminal litigation, they know the elements that can define whether or not an act is criminal or legal based on logic. Trying to logic through the elements of complex fraud cases is highly unadvisable. It really can't be done, and the best practice is to know the elements cold and know all of the statutory, case law, everything that surrounds the specific offense and the facts and circumstances that will come out at trial. The criminal offense of fraud makes a good illustration. A prosecuting attorney can run into some real trouble when trying to prove fraud cases. They are highly defendable. A prosecutor can find themselves in quite an embarrassing situation, being blown out of the water, whereby they make assumptions about any type of criminal law, any governing law about what the prosecutor's obligation is, having the burden of proof. And that's what I meant when I said that. The criminal offense of fraud makes a good illustration of this. Proving fraud. Well, proving fraud would be easy if, as I said when I started this, that an untrue statement made by the perpetrator, is that fraud? Well, no. To prove fraud, you need a bunch of things from an evidentiary standpoint beyond and to the exclusion of any and all reasonable doubt as codified under our Florida law. Sure, it's true that there must be a false statement, but that false statement must also be considered to be of a material fact once it is established that a false statement was made and that that statement was material and not collateral. It must be proven beyond and to the exclusion of any and all reasonable doubt that the defendant had knowledge that the statement of material fact that they made was untrue. It gets a little bit deeper. How many elements did I just point out? Remember, it has to be proven by the state that it was the intention of a suspect or a defendant in a criminal action for fraud to deceive. And not just deceive anyone, but rather the alleged victims. How many elements were there? Provided these things can be proven by the prosecutor, we move on to other elements surrounding proving a fraud charge. This requires that the alleged victim had actually relied on the untrue statement. Next, it must be proven that that reliance was justified when taking all facts and circumstances into account. Have you been keeping track of all the elements that have been established so far just in this lecture? Let's think about it. To prove fraud, we need a false statement. Next, we need that false statement or evidence that that false statement must have been made by the defendant. Next, the false statement had to have been made by the defendant and have been material, not collateral, not ancillary. Moving on, the state's going to have to prove that the defendant had the intent to deceive. It must also be proven that the intent to deceive was of the alleged victim. The victim had to be the target of the deceit. We're not done yet. The prosecutor will also have to prove that the same alleged victim relied upon the untrue statement, and it must also be proven that the reliance was justifiable when taking all facts and circumstances into account. Think we're done yet? We're not. And remember, all of these elements are required just to get into court. That's called a prima facie case that the state has to have before going forward. They have to have a good faith basis that they will be able to present these facts should the case proceed to trial. What's the last element? The last element is injury. The alleged victim had to suffer some type of injury in justifiably relying on the defendant's untrue statement that was intentionally made and was of a material fact and done with the sole intention of deceiving that victim, which the defendant knew was untrue.